I am Palak Agarwal of Hidayatullah National Law University and currently a legal intern at LEXIS and Company. Today, I'll be discussing about vicarious liability. In usual situations, a person is liable only for his own acts and is not liable for the wrongful actions done by others. However, there are situations where a person can be made liable for acts done by others. For example, A can be held for a wrongful action done by B. But in order to make A liable, there should be a special relationship between A and B, and the wrongful act should somehow be connected to that special relationship. Such liability of a person for the act or omission of other person is known as vicarious liability. When an agent commits a tort in the course of performance of his duty as an agent, then the principal can be made liable. The agent is also liable as he himself committed the act. In short, both the agent and the principal can be made liable for the wrongful act committed by the agent. The plaintiff has the option to sue either the agent or the principal or both of them. The same principal will be liable for the acts committed by a partner in a partnership firm. All the other partners are vicariously liable for the act committed by a partner in the usual course of business. Same principle applies to a master and the servant. The master is liable for the wrongful acts committed by the servant. If a servant in the course of employment commits an wrongful act, then both the master and the servant can be made liable for the wrongful action of the servant. The act of the servant is deemed to be the act of master as well. This is based on two principles, namely, let the principal be liable. It means that the principal is in a better position to pay the damages as he is in a financially better position. And also, the other principle is one who acts through others is deemed to act himself. But the real question is, who is a servant? A servant can be deemed as a person who is employed by some other person to do acts under the control of him. The employer is called the master. As a general rule, the master is liable for the wrongful acts by his servant, but is not liable for the wrongful acts of his independent contractor. A principal is liable for the wrongful acts committed by his agent. An agent is someone who acts on your behalf. An agent is someone who is authorized to do acts on the behalf of his principal. The authority to do the act may be express or implied. The principal may not expressly ask his agent to do the wrongful act, but when the agent acts in the ordinarily course of business of his duties as the agent, the principal becomes liable for the same. However, if the agent is acting in his own capacity, for example, as the relative of the plaintiff, then the principal won't be liable as as the defendant acted in his own personal capacity. An agent is different from an independent contractor as agent acts on behalf of the principal, whereas an independent contractor is not authorized but hired to do an act. An independent contractor performs in his own capacity. Relation between partners in a partnership firm is the same as the relationship between the master and the servant. They all are considered to act jointly for the purpose of business. For the purpose of business, any one of the business partners or all of them together can be sued. In Hamlin versus Hostel, one of the partners of the firm bribed the plaintiff's clerk and induced him to commit a wrongful act. That was to leak business information about the plaintiff's business. It was held that both the partners were liable for the wrongful act.